Hello, this is Steve Carlson. I'm going to read just a little bit. I'm starting off this appeal to save the Minnesota Independence Party from being unjustly decertified as a major party in Minnesota, and also to challenge Al Franken and Mike McFadden's handling of my race, the U.S. Senate race, in which they conveniently arranged to just debate each other and try to be as much like each other as possible, and basically did not address any of the issues that really concern the American people. But you can go to my website, which is stevecarlsonforcongress2010.com. Excuse me. So I'm going to read a little bit of a letter that I begun by addressing the canvassing board, Minnesota Canvassing Board, and I'll just start to read from it. It's a letter and petition challenging, first, the certification of the 2014 general election for U.S. Senate, two, the decertification of Minnesota Independence Party as a Minnesota major party, and three, the blocking of all avenues for enforcement of Minnesota election laws, which I believe invalidates this election. My name is Steve Carlson. I intend to run for federal office in the 2016 Minnesota primary elections, either for U.S. President or U.S. Representative with a Minnesota major party. In other states, too, if I can get on the ballot for president. I intend to run with a major party, either the Minnesota Independence Party, and I am challenging herein the proposed decertification of the Minnesota Independence Party based on the results of the general election, or the Democratic Farmer Labor Party, or DFL. I am also challenging the current DFL Constitution and bylaws as a violation of the United States Constitution. See infra. I may run as a Democrat if the party is ordered or persuaded to remove its principle and practice of selection of delegates based on their gender, race, sexual practice, or other group characteristics, which I consider to be a violation of the United States Constitution. I'm sorry, I'm having to flip up and down here because I'm flipping through the letter on my computer. But I believe that these are all quoted groups, which includes gender, race, sexual practice, other group characteristics, and I allege that these are unconstitutional suspect classifications under the 14th and 15th Amendments to the 5th Amendment, 14th and 5th Amendment to the United States Constitution. Therefore, the practice of the state of requiring all eligible voters who seek to participate and vote in the precinct caucuses to agree to these unconstitutional suspect classifications, and I don't agree, must be barred, and this is Claim B. Now, I submit this letter and petition to challenge this body's proposed pending action, I'm talking to the Minnesota Canvassing Board, to purportedly validate results to support OSS certification, that's Office of Secretary of State, the DFLer Mark Ritchie, who's resigning now, of the statewide election for U.S. Senate between myself, Senator Al Franken, and Mike McFadden, held November 4th of this year, and two, the implied statewide ballot question associated with the Senate election, that is to say, the decertification of the Minnesota Independence Party as a major party, the party whose U.S. Senate nominee I became by virtue of winning the statewide primary August 12th. Purportedly, and this decertification purportedly comes because the unofficial results issued by Secretary Ritchie show no statewide nominee achieved 5% of the vote. Now, that could change with the official count. And I guess I can continue on. This seems to be still recording. I got disconnected from the internet here. Sorry. Might come back on. So what I am saying is that maybe they'll get 5%. I don't know. It was 4.91%. But in any event, this challenge is based on the unconstitutionality of the stated procedure of the Minnesota Canvassing Board in light of the state's announcement of the impossibility of bringing a contest or any enforcement action to secure election rights, as set out in the two attached opinions in Carlson 1 and Carlson 2. See infra. These are two lawsuits that I had to bring with the Minnesota Supreme Court, one in 2012 and one in 2014. For reasons set forth herein and enumerated as claims, neither the election nor the related certification question are valid polls, because neither is a result of neither is a result of free, pure, and fair elections. In other words, those elections are not free, they're not pure, they're impure, and they're unfair. Now, such purity of election is required by the United States Constitution, referred to in Yarborough infra as free, safe, and pure elections, and independently by Minnesota election law precedent, as at least since Sari versus Gleason, it's a 1914 case from the Minnesota Supreme Court. Further, because my election campaigns have been for federal office, federal precedents, including Ex parte Yarborough, it's an 1884 case, must be applied. And in particular, this requires that the manner of this election for U.S. Senate be fixed, that is to say, prescribed by the laws established by the Minnesota legislature and enforced by the judiciary. Instead, in Minnesota, once people get excited about the federal elections and the DFL and Minnesota GOP or Republicans get excited about the federal elections and the judges get excited about the federal elections, the election laws are out the window. Democracy simply cannot exist without the rule of law. This board, including Secretary Ritchie, but also the Supreme Court, must enforce the laws. And the failure to do so during elections has been and is a fundamental violation of America's democracy and democratic expectations. I will bring the issues from the 2012 election to the United States Supreme Court in a petition for writ of certiorari, based on claims as amended filed with the Federal District Court in the days before the 2012 election. I have brought claims regarding the blocking of debates to the United States Supreme Court Justice Stephen Breyer on October 31st, 2014, in a motion for a stay or injunction, and will submit a petition for certiorari to that court. Two petitions for certiorari will go to the United States Supreme Court because there's two elections which still have not been reviewed by that court. It is necessary and incumbent on me to use all Minnesota channels to pursue my rights in the 2014 general election, including invoking the jurisdiction of the Minnesota judges who are responsible members of this canvassing board. The Minnesota Supreme Court, in its decision in Carlson versus Ritchie from 2013, that's Carlson 1, made clear that it will not act to ensure a timely contest in this case can be filed, or that the proper procedures notifying a chamber or house of Congress of a timely filed contest, and so the certification must not take place until it is established that an election contest by me bringing the claims herein under Minnesota Statutes 209 is to be allowed by the state of Minnesota. That is to say, ordered by this board. And here's what they said in Carlson 1. And this just shows that they are not going to give anybody any right to bring an election contest that can be enforced. And they say, quote, "The duty about which Carlson complains is the district court's duty to accept his election contest filing. But the obligation of the district court to accept court filings cannot be converted into a duty concerning an election simply because the underlying filing that was not accepted is an election contest. This is so because that statute is not a broad vehicle through which any conduct with any relationship to an election, however tangential, can be challenged. This is another Ritchie case from 2009, the great year that gave us Obamacare, stating that the section does not establish original jurisdiction in this court for any and all disputes related to elections in general. Well, this is a failure to meet the standards of the U.S. Constitution to fix and enforce election laws for Congress. It is frankly ridiculous to pretend that just the judicial parts of the election laws do not need to be fixed and followed and can be interpreted by judges and court clerks. The matter of the contest filing fee, non-existent in the election law, cannot be dreamed up to block the election, which includes the rules and enforcement thereof. Any logical person who is not politically motivated because of his or her election, talking about judges now, or appointment by partisan elected officials, can see that, as Sari said, the enforcement cannot be separated from the statute that needs to be enforced. I am not a lawyer, but I am not stupid. It's hardly worth an intelligent discussion. To fail to take evidence and pass it to Congress, however, or to so order in these circumstances would violate fundamental requirements of democracy. And that's my claim A in this letter to the canvassing board. And so, to the degree any legislative restrictions on the actions or jurisdictions of this board, the canvassing board, are seen as taking away this board's jurisdiction to consider this challenge, they are unconstitutional on their face, as in violation of due process, the First Amendment, and Article 1, Sections 4, 2, and 3. Three different sections are violated of the United States Constitution. And it is a violation of these provisions of the federal Constitution for this board to proceed to, quote, report results, unquote, or certify or in any way validate this election when it knows or has reason to know, as this letter / petition provides, that deliberate, serious, and material violations of Minnesota election laws, including these provisions of the United States Constitution, have been brought in an elections contest, alleging serious, deliberate, and material violations of these election laws of Minnesota by Senator Franken or Representative McCullum. I will set forth infra how I think these cited provisions and others operate to secure for me and for the voters the rights to freedom of expression and freedom of association, and this includes enforcing those rights. The rights may not be secured without being enforced. All of the claims I have brought regarding the 2012 and 2014 elections are regarding actions by the respondents calculated and intended to prevent me from advancing my campaign by putting my positions, arguments, and qualifications before the voters during the election, thus leading to the defeat or diminution of my candidacy and the disestablishment of my party, the Independence Party, as a major party in Minnesota under Chapter 200. These failures of duty concerning an election began in 2012, when an offer by OSS made to me in 2010 and again in 2012 to utilize public information in the form of email addresses of registered voters in CD4, that's Betty McCollum's district in Minnesota, to reach voters during the election with my positions, arguments, and qualifications, was suddenly reversed and withdrawn by Secretary Ritchie. That's my claim C, and Bert Black, his legal counsel. I later learned Ritchie himself has brought home voter and donor email addresses from the OSS, his office, and used them for fundraising and campaigning for himself, because they are public information under the Minnesota Government Data Practices Act. This prevented me from utilizing this offered strategy in 2012 and prompted election litigation. The gender, race, and sexual practices quotas, Claim B, also prevented me from reaching other voters through running for office in the DFL. The Independence Party endorsement is just by 60 people. There are more people than that in many DFL precincts. And by the Minnesota Constitution, Article 7, elective franchise, it is a constitutional right that I be able to attend the DFL precinct caucus and seek endorsement. But under state law, that's 202A.16 caucus, who may participate and vote, I cannot if I don't agree that a majority of women have to make all the endorsements. See Article 3, General Rules and Policy, Section 1, that's in the DFL Constitution, Outreach and Inclusion. And they say they have to select affirmatively such individuals, women, so that such groups, more than 50% women, shall be represented on such delegations in committees and also in the officers and in party offices in reasonable proportion, this is the quota, to their presence in the state. So the presence of women in the state is 50.3%. So this law says that I have to agree to that women are going to run the DFL. Well, why would I run against Betty McCollum or Amy Klobuchar when I, first of all, don't agree, and when 50% of the endorsement is going to be made by women who might know that I don't agree with this? I just believe in all Americans being equal, being able to go to the precinct caucus and decide who they're going to vote for and who's going to go vote at the next level. But the DFL has scrapped this. Now, going to this space to seek endorsement is a way of campaigning. I could reach people if I were able to campaign through that endorsement process. It's of political expression and political association, which is denied to me because of these practices. And I noted already that this violates the 19th and the 15th Amendment, because I'm not, my right to vote is abridged because of my gender and my race. And those are two constitutional violations which the courts in Minnesota are just okay with. Well, those violate the Constitution. Those are constitutional amendments. So, and then this contest was blocked, which would have allowed me access to the DFL voters and access to the voter email addresses. And because the Minnesota Supreme Court in 2012 refused to allow the contest to go forward. This needs to go to the U.S. House of Representatives. Now this year, in 2014, it needs to go to the U.S. Senate. And my question is, are they going to block me from even notifying the Senate of the practices of Al Franken, Betty McCollum, and their party? I'm just trying to bring democracy and free and fair elections to Minnesota. If I could do that, I would be thrilled. I would think that I accomplished a lot. And of course, their refusal was based on what I've just said, that they say the blocking of the contest by the district court is not conduct by a person charged with a duty concerning an election. So an election contest, they say, is not part of the election. But I'm going to show you why legal precedent says that it is. So, but because of this, I can't file a contest in 2014 either, even though I paid a $400 filing fee to run for U.S. Senate. Then in 2014, as I'm saying, Senator Al Franken, Mike McFadden conspired with licensed broadcasters, WCCO, I think it's KBJR in Duluth, Northland News Center, My 9 TV in Duluth, and with NPR Radio and cable companies to schedule only 3 debates, and that all of those would include only Al Franken and Mike McFadden, and that's my claim deed. Now this violates the First Amendment, and I wish to remedy this under the statute 204B.44, but the Minnesota Supreme Court, again, stopped me from reaching the voters by a non-stipulative dismissal of all claims as moved on October 27th. This is Carlson 2. They also used all kinds of other inappropriate equitable remedies in an area of the law that is fundamental. This is elections law. It's not a matter of personal remedies that Betty McCollum or Al Franken have. This is the elections law that needs to be fixed by the state of Minnesota in order to comply with the U.S. Constitution, as I'll explain carefully. And so it's not civil, it's not equitable, and it's not simply legal. It is fundamental. You cannot have any laws or courts if you cannot have democratic elections. This is the problem. Betty McCollum and Al Franken are by no means personally entitled to any consideration beyond the fixed election laws as set out by the legislature. There is no injury to Al Franken by any delay in anything. These questions concerning the 2014 election specifically, and they need to be addressed as it was discussed in a key case from 1912 called Sari, I mentioned, and it was reaffirmed in 1979 under Pavlik versus Joan Grow. No court can determine that these somehow don't sufficiently involve Franken or McCollum, these claims, because to do so, if it was a Minnesota court, would be to impermissibly reach findings and conclusions of law and fact, which our law doesn't allow on a congressional campaign contest. But I believe they do sufficiently involve each, as will be shown when evidence is allowed to be taken and forwarded, certified, to the two houses of Congress, the House for Betty McCollum and the Senate for Al Franken. And this is regarding being allowed to bring this contest to forward it regarding the race with Al Franken. Now, the fact that this state must enforce rules of free and fair elections derives from the precedents of the Minnesota Supreme Court as well as the U.S. Constitution. Beginning with Sari versus Gleason from 1914, the Minnesota Supreme Court first approved the legislative regulation of election campaigns through the then entitled Corrupt Practices Act. Pavlik noted with approval that the provision of the Corrupt Practices Act, or provisions, are justified as a necessary extension of the legislature's acknowledged power to regulate the conduct of election campaigns, expressed in the Fair Campaign Practices Act itself, unquote. The Pavlik court also noted with approval that the court in Sari logically and emphatically ruled that the power to promote fair elections necessarily implies the power to set aside unfair elections. This is from the Minnesota Supreme Court that was reaffirmed in 1979. And they go on. Of what use, this is the Pavlik court, of what use would it be to assess a misdemeanor penalty against the offender of an election law while allowing him to hold the office obtained in part by his very violation? An offender may not reap the benefits of his wrong, Al Franken or Mike McFadden, and unfair elections must therefore be set aside. It is a recognition of the oldest requirement for democratic office of all. The candidate must have prevailed in a valid election. If he has not done so, he may not sit, unquote. And yet Minnesota courts, in my cases, used an idea of latches, saying that using the contest procedure of Chapter 209 injured Representative McCollum because of my lack of diligence. But this is not the purpose of election laws and is contrary to Sari. Further, based on Minnesota Statutes 209.12, congressional elections, no court could injure Franken, no court could injure McCollum by taking evidence in a contest against your results, declaring them as the entitled winners. First, they have no entitlement. Secondly, in the event of a contest, as I filed and am filing a challenge in a letter petition here, all that can be done is forward it to the U.S. Senate in the 2014 general election. That reflects the U.S. Constitution. Again, Article 1, Section 5, quote, each house shall be the judge of the elections, returns, and qualifications of its own members, unquote. This board cannot be the judge, but neither can the district court or the Supreme Court or this Minnesota Supreme Court or a panel of Ramsey County judges convened by the Minnesota Supreme Court. However, by blocking an election contest, if that is the fixed law or required by the U.S. Constitution, or by adding on an additional filing fee of $350 or a similar amount, or forcing a contestant to file an IFP in form of papyrus application, etc., this is usurping the power of the houses of Congress, making in effect a decision. That is, that the declared winner is without contest, which is the very decision saved for the Congress itself, unquote. And what I am telling you is that if you do not ensure that the Constitution is followed, then you are violating that Constitution, given that Minnesota courts have blocked or blocked any avenue for enforcing proscriptions against deliberate, serious, and material violations of Minnesota election laws. That is the issue that is new in Carlson, too. The wrongdoing of Senator Franken, wrongdoing also shared in by the runner-up Mike McFadden. The issues from 2012, not having been resolved, apply anew to the 2014 election against Senator Franken and must be resolved for future elections. They are not moot. This year, in 2014, unlike previous years, a new misconduct occurred. The U.S. Senate nominees of the DFL and GOP colluded to exclude petitioner-challenger, the IP nominee, from an entire general election season of publicly broadcast or any debates. This imposed on me, the IP U.S. Senate nominee, a burden on my First Amendment rights of freedom of expression and freedom of association that must be justified by the state and cannot be. So this is the general trend of the challenged actions of the state. This trend and each contributing acts violate the fundamental requirement that my positions, arguments, and qualifications be put before the voters in the context of the election. And now there is no available contest. I'm respectfully requesting this board to ensure that I may file this contest under Chapter 209 with no further fees, only the statute of limitations, which is 7 days after the correct action by this board, or alternatively, that the proposed so-called results not be issued until it can be assured that I can file without fees within that statutory period, told by the time then that it takes to get the assurance. This is required by law. In these circumstances, only this board can preserve the rule of democracy by ensuring my election rights can be secured through enforcement in a contest under Minnesota law and the U.S. Constitution. I submit this letter of petition to your honors in this forum on the grounds that there are no constitutional fora for these questions to be heard in place in the state of Minnesota or its election laws. And this is my claim A. I speak of the U.S. Constitution, Article 1, Sections 1 to 5, which I examine in from. Because the state of Minnesota and the two parties, the DFL and the Minnesota GOP, have wrongfully blocked all general election debates and all avenues for review of my claims, and on grounds of the other claims already brought to the Minnesota courts but not enforced or reviewed. The election is invalid. On the face of it, there is a procedure in place for election contests, which hold up the release of election certificates until proper procedure on election contests is followed. It says specifically, in case of a contest, an election certificate shall not be issued until a court of proper jurisdiction has finally determined the contest. But in 2012, Mark Ritchie determined that he should issue the certificate to Betty McCollum when no court of proper jurisdiction had finally determined the contest, or was allowed to. And that the only way that could have been determined was to take that evidence and forward it to the House of Representatives. They could have done with it what they felt was appropriate. But your courts, Minnesota, the district, and appellate, have blocked without comment all other avenues to address this fundamental problem with democracy in Minnesota, including disallowing the matter to reach the House of Representatives in 2012 and clearly intending to disallow the contest to reach the U.S. Senate in 2014. And this is Claim A. And only this canvassing board can address it, a major violation of the United States Constitution's requirement for free and fair elections for the U.S. Congress. The 2014 Minnesota Canvassing Board, with the state's chief election officer, 2 Minnesota Supreme Court justices, and 2 Hennepin County District Court judges, cannot be instructed or otherwise coerced by other politicians to act illegally against the Constitution and the fundamental laws of this and all democracies by authenticating and validating the misconduct of the state and the 2 major parties and their federal office candidates, as has occurred in this election, with a meaningless certification ensuing per 204C.40, it's Minnesota statutes, because the law is not followed. That is why it is unconstitutional for your duties to be limited by the 1988 amendment which purports to limit your jurisdiction to only counting the votes, certifying the count only. You must see to it that the other allegations of deliberate, serious, and material violation of Minnesota election rules, including the Constitution, be brought before the U.S. Senate. That is when I am allowed to file it. As the Minnesota court stated in 1979, Minnesota Supreme Court, the court in Sari logically and emphatically ruled that the power to promote fair elections necessarily implies the power to set aside unfair elections, as I have noted above. And it follows without fail that the validity of an election must be allowed to be challenged and enforced in any state scheme for electing members of Congress. And yet, since 2012, and again in this election, the state has refused and still refuses sub rosa and out of sight of the Minnesota voters and of the U.S. House and U.S. Senate to allow the procedure required by Minnesota laws and the U.S. Constitution to be followed. This must stop immediately, and it must be addressed by this body before proceeding to certify these two challenge questions. The blocking of all avenues for enforcement of election laws in congressional elections. As you will know, in reviewing the two Supreme Court opinions of this matter, Carlson versus Ritchie 1 and Carlson versus Ritchie 2, and this title is deceptive. The immediate concern in what is called Carlson Ritchie 2 was against Franken, McFadden, and the licensed public broadcasting media who connived to exclude me from the entire season of general debates, or love fests, between Al Franken and Mike McFadden. In 2012, the attempt at a timely contest to bring these issues to the U.S. House of Representatives were stymied by the Ramsey County District Court and then incredibly brushed off by the Minnesota Supreme Court because it is supposedly not conduct concerning an election when the court specified in the Minnesota election laws blocks the filing of an elections contest to hand the matter off to the Minnesota Supreme Court. Further, the connection with the election is inescapable if you look at Minnesota Statutes 209.045, venue for statewide elections. That applies to this election with Al Franken. That's a statewide election. The congressional election, the House election, was not statewide. It was limited to Congressional District 4. And this 209.045 explains how the only thing the Ramsey County Court is to do is to forward to the Chief Justice of the Supreme Court, who in turn must pick a panel of 3 Ramsey County District judges to hear it. Further, again, under Minnesota Statutes 209.12 congressional offices, the only role of that panel would be to make findings of fact and conclusions of law upon that question, only the count. Evidence on any other point specified in the notice of contest, including but not limited to the question of the right of any person to nomination or office on the ground of deliberate, serious, and material violation of the provisions of the Minnesota election law must be taken and preserved by the judge trying the contest, or by some person appointed by the judge for that purpose. But the judge shall make no findings or conclusions on these points, unquote. And so when either the Ramsey County District Judge or the Supreme Court decides they're not going to allow the contest to proceed and they're just going to send the certificate out to Washington without comment after a contest has been filed, they are violating that law, 209.12, because they're not allowed to make findings of fact or conclusions of law. And they're making conclusion of law that Betty McCullum can sit or Al Franken can sit. Now, I want to challenge them in a contest. And so as the Carlson 1 opinion documents, I did, quote, urge the court to order that a trial be held pursuant to Minnesota Statutes 209.12 to allow for evidence to be taken and forwarded to the United States House of Representatives for use as it deems appropriate. I did do that, and I will do the same in 2014. It's the duty of this canvassing board to make sure that I'm allowed to do that. Now, all of this, including allowing timely filed contests, is specifically required under Minnesota's election law. And the Yarborough Court, which cited the U.S. Constitution, Article 1, Section 4, saying the times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. That's the Minnesota legislature, but the Congress may at any time by law make or alter such regulations. So it's totally regulated, and it's fixed, and you have to follow it. It has to be enforced. Now, the pretext of the district court was that they required I pay a civil action filing fee of $350. The election laws which Minnesota has prescribed and fixed do not require this. An elections contest is not a civil action, and I did not have that amount with me. Therefore, they blocked the contest. Further, I did not have $350 to pay for a filing fee, and my IFP application in 2012 was rejected by the district court judge. They forced me to file it. A very political, elected judge who threatened me with legal penalties if I filed it again. That's the IFP application. However, an election contest is not a civil case, as I explained to the clerk. To sum it up, the claims of deliberate, serious, and material violations of Minnesota election law that I brought before the Minnesota courts in 2012 were blocked from going to the House of Representatives after the procedures required in Minnesota Statutes 209.12 were deliberately thwarted, and the Secretary of State refused to recognize that I had a right to a contest and I must pay an additional filing fee of $350 to the $400 already paid. $350, which I don't have. We're talking now about 2014. I raised no money for my campaign. I spent de minimis, including travel to Duluth and Rochester for a debate and an editorial board review. My wife and I have not worked and subsist on Social Security retirement at present. She has had almost no part-time work since September 2013 when she was diagnosed with cancer. I have not worked since August 2014 because the part-time work was not suitable. I do not have the money to pay a filing fee this year, although thankfully I have come to draw Social Security retirement. However, I did pay a $400 filing fee to the state of Minnesota to run for the Senate, and that is the means by which the state collects the fees to help offset the conduct of the Minnesota general elections for U.S. Senate, and no more should be required. And I ask that this canvassing board find that I wish to contest under Minnesota Statutes 209 and that no further filing fee is to be assessed against me as the evidence is taken and preserved and forwarded to the U.S. Senate. Minnesota 209.12 provides that upon application of either party to the contest, the Court of Administrator of the District Court shall promptly certify and forward the files and records of the proceedings with all the evidence taken to the presiding officer of the Senate or the House of Representatives of the United States. In the 2014 attempt at utilizing Minnesota election laws for a contest, I will do the same. Now, some of this gets a little bit redundant, so and the second part of this goes to the question of the decertification. I'm just, however, going to throw in a little bit more of the argument which I'm bringing in about latches and also about 2012 case. It's not being relitigated in this challenge. It is presented to document how the normal and necessary avenues to challenge the validity of an election have been thwarted in rulings by the Minnesota Supreme Court in both years. There is a symmetry in that issues like the denial of the use of public information for campaigning during the general election and suspect classifications in participation, voting in the DFL nomination processes, these were both brought in a contest in 2012. So a contest was filed within 7 days of the count by this canvassing board, the same one, and I brought that contest. And it was said that it could not be so brought. That's what the Supreme Court said. It took a position that those could not be brought in a contest, and that the statute of limitations in the contest procedure would not be allowed by the Supreme Court, and the issues must be brought earlier, that is, before the election. But when brought directly before the election, in a 204B.44 petition, well prior to and concerning the general election of 2014, it was said they could not be accepted then either. So I brought these issues to the federal court, and they have jurisdiction, and it is on appeal to the U.S. Supreme Court. But had I brought them to the Minnesota Supreme Court, the Minnesota Supreme Court is now saying they could not have been heard in a petition. Therefore, laches does not apply for another reason. Not only was McCollum not prejudiced by simply bringing the petition, or anybody prejudiced, since the House had a right to act, but the state court would not have heard it. I did not lack in diligence by filing in the federal court within 1 day after learning of the change in the OSS position that it would not release the email addresses they offered to me. So I hope that you will follow this. I want to save the Minnesota Independence Party, and I have very strong cases for that. I'll file another short video. And I also want to make sure that we follow the law here in Minnesota. The DFL holds on to power by rigging the elections, as I have said to Al Franken throughout. And he seems perfectly fine with that. In fact, now he wants to repeal the First Amendment so that the body in which he sits improperly would now be regulating all the campaign funding for anybody who wants to challenge him in his position. So he could have gone out and regulated money that other rich man, Mike McFadden, spent in promoting his campaign. Do you think that that will help the First Amendment? I certainly do not think it will. I'm Steve Carlson, and I approve this message.